As discussed, we're here to talk about AI or artificial intelligence. And first, we're going to talk about just what we're going to talk about today. First, we're going to go over kind of the rise of the use of AI. Then I'm going to talk about confidentiality in arbitration, and somewhat in mediation. There's not as much in the way of law on that differs substantially. I'll talk about how it's being used currently, some of the challenges to confidentiality that this poses, and then I'm going to talk about how to manage it in arbitrations and mediations as well, and then some of the potential for future uses. So with that, I'll go ahead and get started. And as discussed, we'll answer questions at the end. Happy to stick around and answer questions. Let's talk first about the influence of AI. It's really seeping into so many things that we do, not just in terms of legal work, not just in terms of arbitration or mediation, but overall. For example, you can see some of the statistics cited here from various studies the expectations. One interesting tidbit I thought about a year ago, ChatGPT was given the Arizona bar exam and passed it. Just to give you kind of an indication of the capabilities of AI. Now, that's not to say it'd really be a qualified attorney, but of course, in terms of the basic fact knowledge and the ability to present that in the bar exam format, AI is there already. Okay. So one grave concern talked about in the context of AI is that it's going to be the end of employment, that it's going to take everybody's jobs. And so one thing I thought was interesting, if you look here, statistics over the decades in terms of the percentage of the U.S. population engaged in agricultural work, as you can see, it's dropped dramatically to the point where uh, many of us know few or no individuals engaged in full-time agricultural work, and yet obviously the economy has grown tremendously. And I offer this as an illustration to the point of, we need to think about not the fear factor of AI, of what of the calamity that could ensue from the integration of these various tools, but rather more about the opportunities that it'll be opening up and thinking about then how can we be integrating that or being aware of it to do our work otherwise. So let's talk about confidentiality in arbitration. First we'll talk about arbitration, but I think this applies for mediation as well. It's a long-standing benefit of both of these forms of alternative dispute resolution. It's something where people have sought these out. A large part of mediation, I believe, is the ability in many cases, not always, but in many cases, to be able to settle something outside of court. Okay. Obviously, there are other benefits. We could discuss that separately. Uh, but I think that confidentiality is a key feature of ADR, and it has been historically for a variety of reasons. There's always been the potential of some disclosure through enforcement actions. That is to say, you reach a settlement or you get a ruling or an order in an arbitration, and the party that needs to pay, for example, doesn't pay. You got to go to court to enforce that. There's always that potential for a disclosure that's been hanging over ADR historically in a pre-AI world, right? Talk a little bit about these privileges since we are here for MCLE credit. The attorney-client privilege, kind of the key elements of this are that the communication had to be intended to be confidential, is kept confidential, and that was made in the pursuit of seeking legal advice. I don't know if folks remember a few years ago, there's a case famously where Google had certain divisions that were CCing in-house attorneys on every email they sent in effort to protect them with attorney-client privilege. And I would argue, fortunately, that didn't work out well for them. The court did not uphold that. Um, but my point here is that something that seems pretty basic, like something we learned years ago in law school, still continues to have opportunities for development in the field of law. I have some other language here. I'm not going to read it all off for you, but I think the broad purpose of attorney-client privilege to encourage that frank and open discussion between a client and their attorney. That's really the key. And again, it's about being confidential information kept confidential and about keeping that line of communication open for legal advice. Okay. There's also the work product privilege. This is another key component in and around confidentiality. It doesn't require actual litigation. It usually consists of ordinary work product, but depending upon the extent of the attorney's work and what expert work or expert opinion work is necessary, it could include other work that's brought into scope by the attorney. Okay. As we get into more complicated systems in our world, especially things like AI, and we'll talk a little bit about the opaqueness of these tools. That's important to remember, right? That attorneys sometimes need other experts to investigate, to help them. And in that help, there's also the cover of the work product privilege, excuse me, the cover of the work product privilege for those instances as well. All right. Now, the confidentiality privileges can be waived through a variety of means. One we talked about a little bit ago. One of the key elements of attorney-client privilege is disclosure. I'm sorry, is that it's kept confidential, so disclosure of the material can be a waiver. If it's adjacent material, sometimes that can be in scope and of a waiver as well. Sometimes not, right? As with anything, you gotta study up on the case law for the particulars of your situation, but it's something to be aware of. And we talked about, disclosure to experts does not necessarily entail disclosure overall. And then, you can share sometimes with parties where there's a common interest regarding the litigation or prospective litigation, right? Okay, so. With that, let's talk about some particulars where you've got arbitration rules, give you particulars of confidentiality. Mediation, the rules are going to be governed by the jurisdiction. They tend to be broader. Mediation, generally speaking, is favored by the courts, not just because it's better to have parties work things out, but also obviously lightens their calendars. So, there's going to be a bias towards confidentiality for mediations. But in arbitration, it's kind of interesting because it's not necessarily the same cone of silence that drops over in arbitration the way it does in mediation, right? In mediation, you're limited as a party, as a participant, in what you can do with that information after the mediation if the mediation session does not work out. In arbitration, you don't have those kinds of limits. Arbitration limits are placed on the arbitrator, on the arbitration body. Generally speaking, here's a particular example from the JAMS rules, but generally speaking, this is what arbitration rules provide for. The arbitrator has to keep it confidential. The administrators have to keep it confidential, but otherwise, the confidentiality in arbitration is dictated by the agreement of the parties. Now, the parties may agree to that when they agree to their original contract that then invokes arbitration, or they may agree to it later. That's up to them. They may agree to it, in fact, as a part of the arbitration. Protective orders are the most common example you'll see of this, where the parties agree on a protective order to put in place, right? But it's important to understand that that kind of cone of silence that drops over a mediation or the protection of a legal cone of silence does not exist in the arbitration world. Okay. Um, Now, confidentiality agreements that are worked out either before an arbitration session or during or as a part of it Don't necessarily allow for an enforcement action to be limited. That is, that if an enforcement action has to occur, right, you go through session, you get a settlement and mediation, you get a ruling in an arbitration. Party doesn't pay, party doesn't do something that they were ordered to or otherwise agreed to do, and you gotta go and enforce that in court. The courts, generally speaking, are not going to recognize the confidentiality agreement for the limited purpose of enforcement. Whether or not that means it's going to be something that's protected by the judge by an in-camera review or something that will be out in open court is going to be dependent probably on the confidential information. Also, frankly, I suspect it'd be treated differently coming from a mediation settlement versus an arbitration proceeding. But there's not necessarily that same protection in place that you might immediately assume. So I know arbitration has this reputation of being it's confidential, it's discreet, but there are limitations on that. Okay, let's talk a little bit about AI secrecy itself. So without getting this is a great quote I thought from Perplexity.ai. If folks haven't utilized Perplexity, I like it. I enjoy it. Use it regularly. It's great because it provides thorough citation to its sources, so you can go ahead and follow up on is that true or is that a hallucination coming out of the AI, right? There are a couple of efforts out there that are trying to provide transparency, but generally speaking, these AI tools, the models that are driving these tools, are considered by the development, by the companies as proprietary information. They're protecting it, right? They're trying to. There's some open source AI tools such as Meta's Llama and the like, but broadly speaking, the vast majority of the AI tools out there, we don't really know what happens in the black box, right? Um, but some things that are being done around that are one interesting initiative. Now, I don't know how far this will get pursued, obviously, with the change in administration, but uh, late last year, the DOJ updated their corporate compliance rules, saying that if companies utilize AI in their compliance efforts, then that's going to be inspected and considered with the same gravity or greater, depending on the reliance on those tools, as if it were individual employees taking those actions. So there's not necessarily an automatic cost savings coming from uses such as that, right? All right, so let's talk about how AI is used currently today. So parties, your clients in mediations and arbitrations are utilizing it in businesses regularly, not just necessarily the large businesses that run the kinds of server farms you see in this AI generated image here, but all kinds of businesses are utilizing AI, and many in ways where they may not necessarily know that they're fully utilizing AI in what they're doing. There's a lot of different products out there. I mean, it seems like most tech products, if they possibly can integrate some kind of AI into the product, is doing so. This can be a problem, though, for discovery issues in terms of getting from these parties, what the prompts were that were utilized to conduct research, background research, perhaps, and also whether the records are actually kept. And that can be dependent, as we'll talk about a little bit, about whether it's a paid product or a free product that's being utilized. Um, there's also confidentiality concerns for the businesses themselves to explore. Excuse me. In terms of whether or not the prompts that are being developed and the AI requests that are being made, is there a confidentiality in that itself, kind of an intellectual property, if you will, and also what is there an employee work product? What if the employee has left, right? If it's an employee who's brought in specifically to use AI for particular work, just depends on the circumstances of the case. Attorneys are using AI more and more, and there's lots of different ways that this is being done. Things such as document review software tools. If you think about keyword searches, that's a version of AI that predated ChatGPT and kind of the AI revolution. But it's the same idea. Um, Coming up with those keywords. AI is being used for that. AI is suggesting keywords now integrated into many of the e-discovery tools. There's also a lot being done in terms of relationship mapping. That as you know, there was some of that being done pre-official AI revolution, but now it's super well developed. It's integrated into many different tools, e-discovery tools, and otherwise things that are very helpful for an attorney putting together a case, but can create questions about reliability. Okay. Legal research, there's a variety of tools out there. There's only going to be more in that space in terms of finding that legal research, in terms of, obviously we all know the stories. We've seen the stories of erroneous court filings, people asking AI, write a brief for me. Go ahead and here's the parameters. And then the AI just makes up cases. That being said, I'm sure the mediators and arbitrators and former judges who are on the line today know it doesn't take AI to make up or miscite a case because I think we've all seen that in various contexts by live attorneys before AI. So it's more of an issue of doing the homework to really check the case. And does that say what it's cited for? Okay, but some of the other different uses here, talking about trial strategy, cross-examination, um, feeding in the transcript from direct, feeding it as well as all of the tools in e-discovery and having it identify for you areas to focus on in cross-examination. I think these are useful tools in terms of coming up with new ideas of points to hit upon or identifying potential inconsistencies. But at the end of the day, a person has to be looking at and doing the work of actually verifying were they being inconsistent and can I use that effectively in the more so than just the legal or technical aspect of cross-examination, right? There is that theatrical aspect to it that's still going to require a human element. So, okay. Let's talk about neutrals utilizing AI. So, there's a couple of different things and guidance out there about the use of AI, drafting rulings, and other uses. And I think the core, without going into all of the guidance that's out there and where I see it developing, is around the fundamental function of a neutral is to provide that judgment factor. And so if you're asking AI to go through materials of the case and identify for you the key points, identify for you potential inconsistencies in testimony and evidence, generally speaking, I check the rules of the particular tribunal, but generally speaking, that's in the spirit. Okay, now you're using a tool to help you. If you're asking it, though, who should win this case? How much should the award be? What's the reasoning to justify that ruling? That is the information that I think crosses the line into making an active judgment, and that's something where you want to steer clear of. All right. Now, as a mediator, I think it's potential, again, confidentiality concerns, and we'll talk about how to ensure that in a moment. But as a mediator, if you want to feed the information in and have it help you to identify potential opportunities of agreement or potential alternative solutions that could bring about a resolution, as long as you've made the disclosures, folks are aware of what you're doing and they're comfortable with it, I think that's going to be all right because it's again, you're reviewing it before you're presenting it. You're not just generating as a work product and firing it off, hopefully. Um, you know, AI is being used a lot, though, in a lot of online dispute resolution. These are small dollar cases, smaller matters, generally speaking. There also is in the, something for here in LA County, small claims court, unlawful detainers. This is really that online dispute resolution is much more of a tool to just facilitate settlement communications back and forth than actually AI itself. So I want to be clear about that distinction. But when you talk about when you these platforms such as eBay, PayPal, etc., that have a large volume of transactions, and generally speaking, it's much more cost effective to utilize AI tools for an initial review. Now that obviously is different than what I just said, right? But those are instances where people are agreeing to that up front, right? Knowingly or not, that's a separate question, and we can talk about that otherwise. So, okay, legal tech market for AI is huge. Everybody on here knows that just from, all of the spam email and advertisements you get for AI products in the legal tech space. We don't need to go over the particulars of all of that. But let's talk about some of the confidentiality challenges that the AI tools themselves face. So you have vulnerabilities from cloud storage. Remember what cloud storage is? It's multiple copies of the same information being stored in multiple places so as to ensure redundancy in case something happens to one particular server, but also to ensure easy access. So if you log on to your ChatGPT account in Southern California, and you type in a query, the computer can respond relatively quickly at the speed of the internet, right? Now, let's say that you're somewhere on the East Coast. You don't want to wait for it to have to go back to a server located back in Southern California, right? So these cloud storage systems provide duplication for both convenience and for protection. Now, that that creates issues in terms of where does the data reside, what's the governing jurisdiction, because cloud storage, unless it's specifically specified, cloud storage does not exist in just one jurisdiction, either one nation or one state, right? I guarantee you anything you have in cloud storage, including your emails accounts, for the vast majority of folks, those who don't have their own email server they operate, it lives in many, many locations, and that could include on copies of servers located on other continents, other countries, all over the place. So you got to think about those jurisdictional issues of what provides that protection or not, right? Uh, there's lots of threats from cybersecurity threats in terms of AI systems provide an additional attack surface, meaning another way to get at someone and get at their information. Okay. Now, also, you have more traditional attacks can become more sophisticated, right? Instead of getting the Nigerian prince email, your phishing attacks are using broken English because it's someone from another country trying to get you to click on a link and enter your password. Now, using AI, they can become sophisticated with graphics, clear language, all of that, right? It becomes more difficult to defend against those kinds of attacks. Um, Also, something to think about if you get deep into this world, there's something called encryption at rest versus encryption in transit. The difference is that when data is at rest, meaning it's stored on a server, it's on the, in a place where it's a steady state, uh, it can be encrypted, and there is a decoding mechanism, whether it's on that server, on your laptop, whatever it is. When it's in transit, you need to have both an encoding and decoding mechanism at either end. All right. So if you're mixing and matching AI products, the encryption may not be there. It may not be a seamless encryption between these products. What does that mean in English for a non-technical user? If you're using a legal tech product that wants to use AI to be helping you write your briefs and ensure that the citations are legitimate citations, and you're not going to get in trouble with the court for filing something that is to a made-up case, and that's operating on top of, you're using that integrated with Word and Office 365, let's say, and you've got Copilot integrated into that as well, right? The Microsoft product, which is based off of a Chat GPT uh, model. Unless that product is specifically designed to integrate, not just integrate into the application, right? Having a little link in the corner, but integrate with the encryption throughout, you may not have the encryption and confidentiality protections that you need depending on the work that you're doing. And again, the disclosures that have been made to clients or participants in your proceeding. And so this is where, it needs to get into those strict controls, authentication measures, and understanding of who can see what, how it's encrypted, where that encryption lives. Okay. Hopefully that's as technical as we're going to get here today, but uh, there's also some process vulnerabilities. Now, these are, you need a large data set for training. I think a lot of folks are familiar or have seen the news stories about, for example, various books and articles like the whole of the New York Times being utilized to train the LLMs. Um, and then putting in uh, the that information, and that's now your base. Okay, uh, that means that if something that's published in the New York Times, obviously you don't have a confidentiality concern. But if the language model needs that information to utilize it for other purposes, okay. So for example, you use the free version of ChatGPT, you type something in, you say, here's a document, here's 100 PDFs of all the discovery in this case. Go ahead and sort it into a clean table for me. That's great. That's exactly the kind of use AI can do. The thing is, remember that, especially on that free version, it's going to be keeping that data and it's going to be utilizing that data to understand when the next person comes and asks for something similar, right? So you ask for a table of this 100 PDF documents, and then other people are going to ask for that. But you ask follow-up questions to it. Oh, actually tweak the table in this way, add a column that adds this in, et cetera, et cetera. It's noting those follow-up questions. It's noting the underlying data, and it again, unless you have the right product and the settings are set in the right way, that can then become fodder for the next user who comes along and does something similar, makes a similar request. And that's the point, right? The tools are supposed to understand what they're supposed to be doing and how to be more helpful, but we just have to be mindful of how they work and why those confidentiality concerns can crop up. That also can mean, there could be unintended data exposure through outputs, right? That's a key concern. So let's take that earlier example, right? You take 100 PDFs, you put it in, you say, "Hey, give me a table that summarizes all of this evidence," and it does so. And then I go on and I say, "What are some of the uses?" I guess completely separate. I go on and say, "What are some of the uses a lawyer can make of AI or an arbitrator or mediator?" And it says, "Oh, well, let me tell you, one of the great things I can do, for example, is I can make a table like this table, and I can do that for the evidence in your case. And the evidence that's in there, or the information that's in there, that sample information, could be the confidential information that was put in by that prior user, right? Because remember, it's remembering everything. This isn't to say that that's all AI. This isn't to be doom and gloom. My point is, by understanding how it works, we can understand what we have to be mindful of. Okay. All right. Then there are direct attacks that are possible as well in an AI world. Model inversion attacks are where you're trying to an attacker is trying to deconstruct the model itself. Not as of great of concern for us. Again, depending on the case, though, could be. Membership inference attacks are where you're asking, I go on afterwards, after you put in your 100 PDFs and asked for that table, I go on and ask it, what are some uses that someone can make of AI? And it gives me that sample, and I say, oh, that table looks interesting. Tell me more. Give me a longer version of that table. And the AI, trying to be cooperative with user number two, goes back and pulls the information from user number one's request and thereby provides information there. Also, it may not provide all of the information, but I can infer as user number two some of the missing gaps in there, or I can infer what information was provided by that user number one, and then potentially even backtrack to identify user number one. That's pretty sophisticated. I don't know that most instances need to worry about that. But again, it's something to be aware of. And then finally, data poisoning attacks. This is if somebody were to go in and dump into the AI, for example, a bunch of fake cases and fake citations and say, the law says X, and here's a bunch of fake cases that say X, and dump that into the AI. Well, now the next user comes along and asks about that topic. The AI doesn't know that that's fake. So the data pool has been poisoned now. And that's something to be concerned with as well, which really can be corrected for, as we said before, just, checking the work. Okay. All right. So let's talk about hallucinations. Uh, this is a fun one here. The first one here asked AI, and I forget which model I asked specifically, but I asked it what the world record is for crossing the English Channel on foot. Obviously, can't be done. Obviously, this Mr. Wansrach is a made-up person. This is a made-up time. AI wants to be helpful. The tools are designed to be helpful. They are designed to give you an answer. So you ask it an impossibility, and rather than tell you that's a ridiculous question or that's impossible, it will defer to trying to find an answer for you. Okay? Um, One interesting case that was late last year, Air Canada had a chatbot on the Air Canada website, and it recommended a discount to a passenger that the passenger was not eligible to receive. And the passenger went ahead and booked for that. Air Canada then said, no, you have to pay the full fare. Turned into a lawsuit. It was a small claims action, I believe. But it was, and I have the citation if folks want to read more about that particular case. But the court said, no, your chatbot said that they could get that. You didn't have any disclosure language saying don't believe our chatbot, which companies don't want to do, right? I mean, companies are putting the chatbot on their website so as to reduce costs and avoid you having to talk to an operator. Because if you go on the chatbot and it says don't believe our chatbot, am I going to waste my time talking to the chatbot? Right? So, just something to be aware of that entities can become liable for some of what these tools do. Okay. All right. Moving along here. So, how to manage AI in arbitrations. We have guidance for arbitrations. I am not aware of direct guidance in mediations per se, but I'm certainly open to hearing if folks know about that and would like to share when we get to question and answer period. I'd love to hear more about that. One that I found is the Silicon Valley Arbitration and Mediation Center. The guy it has a number of guidelines um, talking about really a lot of the things that we've been kind of talking about here so far. Also, JAMS has issued some artificial intelligence guidelines. Largely follow the JAMS arbitration rules. It's more for disputes arising under AI tools or directly involving AI tools than about the use of AI in otherwise non-AI disputes. But also, a lot of it's about looking at core principles. That's the same guidance, I think, across the board of what I've seen out there. All right. So, how to manage confidentiality in all of this. So, one thing is to do, as I've said, trust but verify. Go ahead and, use these tools. Use them responsibly, okay? But use them, understand them. We can benefit from them, but uh, don't give them all of our homework to do, okay? Do the homework to follow up as well. All right. We want to limit the sharing. Okay, so you don't want to include confidential information in your AI prompts if avoidable. If, however, you really do want to explore this, then you're going to need to use the enterprise systems. Okay, and that what I mean by that are the paid products. Okay, uh, if you're using the free version, generally speaking, that's going to be training data. Generally speaking, all the major products I've gone through the terms of use for many of them, and all the ones that I use, I can tell you, you do have protection with the paid version. You have protection that they're going to provide, that they're going to ensure the confidentiality. They're going to segregate it out. Okay. And so it, I think it's great. I think they're useful, but you just want to be mindful of how you're utilizing them and what you're utilizing them for. Because if you don't want to pay for the paid version, that's okay, but understand, limit what you provide to it appropriately and thinking about would I want this information to be provided in a future response to another user? Or do I want it to be known out there that I was providing this information to the AI tools? Okay. You can set data controls. All right. You can adjust, for example, adjust the training settings. This particular screenshot is an example for Chat GPT. Okay. That's one particular setting, okay, that you can be utilizing. And you can do that you can do some of that in the paid version. Um, I'm sorry, some of that in the free version on some of these products, but not all. Okay, and generally it leans the other way. It leans against it for the free versions. It leans towards allowing for it in the paid versions. Sometimes in the paid versions you have to turn on the setting as well. So you kind of got to do the homework. Okay. This does not, it's important to understand that doesn't mean that the information is not retained at all. The information is retained separately because the company can still see it on the other end. Okay, so in this particular example, ChatGPT, you can do this, change the setting for your training settings for the free version, but that doesn't mean that the folks at OpenAI don't have access to it, right? And you don't know necessarily and that's really dependent on OpenAI's security and their policies and their employees abiding by said policies. So it's important to be aware of that limitation too. Okay, so check the terms of service. Some have clear statements. Copilot, for example, has a clear public statement. I don't know if it's a press release per se, but on the web page. But the terms of service are a little more ambiguous. There's more wiggle room in it, not surprisingly. Google, on the other hand, for example, they have a very clear statement about the use of the data you provide to their AI, and I couldn't find anything in the terms of service that was limiting them. So really, the only thing they're limited by is their public statement, which I suppose is enforceable through litigation with Google, but that could take a while and be costly. Good luck with that, especially since, as we discussed before, the there's other issues. Uh, I would say in terms of the email tools that you use, if you are using an email tool that's like a Gmail account for your mediation or arbitration practice, be aware that if you are using these free email accounts and you have not adjusted the settings, you may be providing that information unintentionally to AI, even if you have never typed a prompt and have no desire to have anything to do with any of this stuff. Same for cloud storage. And again, most often, this is about the free version versus the paid version, right? Of many of these products, if you're not sure who's paying for it, they're paying, the old saying, right? You are the product. So sorry to bungle that, but I think everybody gets that concept, right? And also, recommendation is to take a look at your contracts. Okay. It may be your mediation agreement. It may be the agreement. Now, usually arbitration obviously is through a tribunal, some kind of an arbitration organization. And so their contracts, many of them, their contracts take this into account. But if you're handling your own contracts for your neutral services or you're representing clients as an attorney, you can incorporate these items into your contracts and make it a part of the discussion. At least you have some disclosure there as to what you're doing with it, as to what they're doing with it, um, and the like. Okay? So, just some things to consider here. Yes, we've talked about some things that are scary, but nonetheless, that doesn't mean that AI is going to be all bad. It just needs to be adjusted for. The growth of AI is inarguable. There's a couple of different statistics going on here. These I'm sure how uh, AI is growing, and these statistics I'm sure are out of date already in certain respects. But it's important to understand that while it is gobbling up many things, there's still the core principles that we can return to and guiding us in our usage. And with that, let's talk a little bit about the future. Okay. So some of the potential ideas is, what is an understanding of confidentiality? Is that going to be shifting? Obviously, we have to be abiding by confidentiality rules that are in place currently. I'm not advocating for not doing so, but we want to think about what is considered confidential, what is considered private. Folks of different generations I talk to my kids about privacy, for example, and my high schoolers have a different understanding of what that means and what the reasonable expectations are than I have, and certainly than their grandparents have. So it's about understanding that shift because that applies as well when you think about confidentiality in the business context. Okay. Um, Also think about where else is AI going to get integrated into and what that could mean for confidentiality. If AI is integrated into the products where the original information is created, I'm not just talking about it being in Microsoft Word and the brief that you write or the ruling that you write, but if it's in Microsoft Word, so it's in Outlook, it's in all of the tools that are utilized in that office, then is the work that was done in that office, is that confidential still, right? How did they have it set in terms of their settings for the use of those AI tools? That's something to consider as well. And what does that mean as AI becomes more of tech products? Um, there's going to be more standards and regulations around AI's usage. We talked a little bit about it in the context of ADR and some of the rules that have come out. There's going to be more. There's going to be more developments in this space, especially over the next few years. Some of the foundational sets of rules are going to be put into place. It does appear that it's really taking off at the state level in terms of governance, in terms of regulation, rather than federally. There is, in Europe, the GDPR privacy bodies are moving into the space as well. But there's a variety of views, and that's all going to have to kind of settle out. Um, and what are and then thinking about just what is the role as a neutral in adapting to these changes, and understanding the use by party participants, understanding the use by admins, understanding the use by neutrals themselves, and if you're on a panel, for example, the other neutrals of the panel. Okay. So with that, we do have about 10 minutes left here, and I will go ahead and open up or I'll ask Jasmine to open it up to questions, uh, and see what we have here in the Q&A. All right, I will start with the first one in the Q&A is there a finding that AI chat GPTs are, quote, agents of the corporation they represent? Okay, so this the short answer is no. I have not seen that directly, okay, in terms of a particular AI tool or AI product. But I will refer back to that Air Canada scenario I spoke of earlier, okay, where the finding there was that and maybe this was, I don't know when the question was typed in, maybe that was in response to that part of the discussion. But yes, so there the chat GPT, I'm sorry, I completely misspoke. I apologize. The chat bot itself was found to be an agent of Air Canada. Okay. So in that particular instance, now I don't know what AI tool was being utilized, but the chatbot was found to be an agent of the company because of the steps that were taken by the company to put it on their website, to offer it up, etc., etc. So that does open up this potential, right? It's not unheard of. And I think it's reasonable. I also think it's something that requires context for understanding of if something is acting as an agent or it's merely a tool that's being offered by the entity. That obviously there's a lot of factors that can play into that, but in that particular instance, that particular chatbot was found to have created that agency liability. All right. Next question. Right now, what is the best AI tool for legal uses that has the best confidentiality protections? Okay, so it's not a short and quick answer. The first, I guess I'd answer your question with a couple of questions. The first one is, what do you want to do with it? For example, if you're looking to do research on a topic, I mentioned Perplexity earlier. This is not an endorsement. I'm not getting paid by anybody. All right. I can tell you what I use. I use Perplexity for research primarily because it provides you citations, which several other products do now. ChatGPT has gotten better at that. But also it provides you deeper citations. Okay, there's more, it's deeper. It's the best way of really finding the core of where the information came from that the tool is relying on, and that's what it's designed to do. Okay, that's their killer app at Perplexity, right? They designed it. They're based off of, I believe they're based off of the OpenAI. Um, but he designed it to provide that kind of product. Claude, on the other hand, I believe the company's Anthropic. I use Claude. I use Claude for writing, more for creative writing. I don't use it for drafting rulings or orders or anything like that. But I use it more for written product because I find that it's a better writer. It's a different tool. It's designed to do that differently and better, okay, than the research tool that Perplexity is offering. Okay. Um, I gotta be honest, because I don't put anything confidential into Claude, I have not actually looked at the terms of use of Claude. I have the free version of Claude. Okay. Perplexity, I have a paid version. Excuse me. I don't necessarily put in confidential information, but if you were to track back and look at my searches, you could figure out some of the things I'm working on. And so, not not I'm doing independent research necessarily for a case I'm handling as a neutral, but otherwise. And so, because of that, I have looked at that. That's part of why I pay for Perplexity. I'm confident in the confidentiality protections there. Um, OpenAI, the ChatGPT, I have a subscription to that. I utilize that tool. Um, I don't put case confidential information into it, but I put information that I personally would consider confidential into it. I'm happy with the confidentiality protections there. One thing I avoid, I know I've talked about a bunch of different tools here. One thing I avoid is I don't necessarily have them stack and tie together automatically. I will, which you can do. I mean, that's starting to become a thing now, and there's tools that will just stack them all up for you. But as I talked about, that gets into the encryption in between aspect, right? And so I will maintain I'm kind of manually moving in between if I'm moving between tools. Um, in terms of email, I have my own, my own email, my own server space I rent, and so I don't utilize Gmail, Yahoo, Hotmail, any of those kinds of free email products. So I don't have to worry about that. And then for cloud storage, I have a paid subscription, and where again I've gone through and looked through the terms of service myself. Um, just because it's something that's relevant in terms of just being aware where things are living. So hopefully that's helpful for you. I'd say, I know it sounds painful and daunting to go through the terms of service. Honestly, once you've gone through one or two of these things, it's pretty straightforward. You know where to be looking or the keywords to look for in future service agreement reviews. But if you're going to be, depending on what you're putting into it, and obviously if you have confidentiality obligations to third parties as a neutral and you're putting that kind of information into it, you do want to make sure that you've done your homework in that regard. Um, but it's not too arduous. Again, after the first one or two, and I'm certainly not suggesting to read the whole thing. Nobody's gonna lie to anybody that they're reading the whole terms of service of everything they sign up for. So hopefully that was helpful and answered the question, or at least gave you some guidance as to where to head with it. Any other questions that folks have? Anything I can be of use otherwise? I don't know, otherwise. Or Jasmine, if you've got any questions, maybe people are shy out there.
Not myself, but everyone, you are welcome to put your questions in the Q&A section on the bottom, and we will go ahead and address those. But besides that, David, you've been super generous with your research, with your advice, and your own personal practice. So thank you so much. For everyone who may have been a little overwhelmed with the resources he shared, you will be able to access this recording of this webinar on our website. Just for a refresher, if you want to share this with your colleagues, it's super valuable. So that will be available on our website. And as for those MCLE certificates, for anyone who didn't hear at the beginning, we will be issuing those to your email that you registered at. So you can
Yeah.
expect those within the next couple of weeks. If we don't have any more questions.
It doesn't look like it, Jasmine. I'll just put this on so we have it on the recording, or folks that are live. If you want to reach out to me, feel free. Coheradr.com. It's COHERADR.com. My email's on there. My phone number's on there. You can reach out. Happy to answer questions. Happy to share with you, citations and the materials that we've talked about here today. Okay.
Wonderful. Thank you so much. And one thing that I did forget to mention is David is our newest addition to our mediator panel.
Yes.
For all your mediation needs, you're able to request him for any cases you may have at mediationla.org. He is up there available now. His resume is there for his review. And like he mentioned, you are welcome to contact him at his email he just provided. So with that, we'll go ahead and end today's webinar. Thank you so much, David. Thank you everyone for joining.
Thank you, and thanks everyone for joining.